Chapter 6, Establish Your Legacy. How do you want to be remembered? My grandfather died when I was 17 and left me $5,000. It was a huge amount to me. I was able to buy myself my first car. I still remember the feelings. It was because of his legacy to me. There are various ways you can create your legacy without leaving a cash amount to someone, as my grandfather did. Types of legacy. One of my clients created an annual family event, like a reunion, during her 70s. She left money earmarked for food and entertainment so the family could carry on the tradition after her death. Another client of mine had 2 kids and 5 grandkids. She left money to them all in a segregated fund, along with a separate bequest to hospice. She detailed these bequests in her will. Yet another client funded a bench at his favorite park with his name on it. Others have created scholarships or funded rooms in hospitals. Leaving money to a charity by bequeathing stock market shares, a life insurance benefit, and property are all ways some of my clients have created a legacy and benefited from tax advantages. Legacies are as unique as you are. How do you wish to be remembered? Who will your legacy support? For your special needs dependent. The Henson Trust is a special way to protect your assets for a family member with a mental or physical disability beyond the Ontario Disability Support Payments, ODSP. However, and again this is for Ontario, if a parent dies and leaves more than $100,000 outright to a disabled child, the ODSP benefit goes away. You might believe the large sum of cash you leave will be enough. Don't assume this. Having a lawyer establish a Henson Trust protects this child's inheritance in full while also protecting his ODSP benefit. How to use life insurance for a legacy. Needs change throughout life as far as life insurance goes. When you are young, you get it as a protection for income replacement, a mortgage, and your family when you have dependents. Later, as your children move out of the house, you have insurance to cover the cost of your funeral. But you might also want to make sure there is money to help pay for weddings, higher education, or special needs family members so they can afford care for their whole life. You might want to ensure that your money goes to the next generation tax-free or the charity of your choice. Name a beneficiary on your insurance policy. You can spell out in a will how the money is to be used. We have a gradual inheritance strategy or annuity settlement option, which is a gradual payout of the sum to help you help your heirs. If you have a granddaughter to whom you can and wish to leave $1 million, yet do not wish for her to have the whole sum at once, use a gradual inheritance strategy. It might pay her $20,000 a year until the policy runs out. Real people. Don't give it all in one lump sum. One of my older clients, Frances, had 8 adult children. 2 of them drank heavily and gambled addictively. Understanding their lifestyles, she set the policies up using the gradual inheritance strategy or annuity settlement option. Frances and her late husband worked very hard to accumulate their investment assets. Naturally, all her kids clamored for her to bequeath the entire lump sum to them at one time. The kids complained and threatened to call a lawyer if she didn't. Well, I laughed and got Frances laughing too. Why? Insurance companies have battalions of lawyers. Even though my client understood that her children would be unable to change her policies, their behavior prompted her to set up policies with gradual payout strategies for all of them. Although the grown children didn't see it at the time, Frances really did give them a gift by paying the funds to them over time. Setting this up through an insurance carrier's policy is best. That way you don't have to change your will every time there is some life event. When new grandkids come along, you reallocate the money versus paying a lawyer to redo your will with such changes. You could set up a trust to achieve this, but it is a less expensive process through an insurance carrier. Cascading. More affluent people with lots of additional cash flow want to put their money somewhere else. Parents can buy a policy on their own life with their child as the beneficiary. This is fairly traditional. There is another option. It is a 3-generation setup called cascading. Grandma owns and pays for the policy to ensure her child's life as a contingent owner, naming her grandchild as the beneficiary. Even when grandma dies, her child takes over ownership of the policy, which remains intact for the grandchild. Leave a legacy, not a mess. Planning for retirement is not only about having enough money for all of the years of your life, it can be about leaving a legacy. You don't want your legacy to be that Dad left a real mess of paperwork, or woo, Mom sure didn't have her assets well documented. Legacies call for some reorganization and planning, just as your financial foundation does. This planning is about not leaving a mess for your family, beneficiaries, and heirs upon your death. You have earned and saved all this money. You have done all this financial planning work up to this point. Now you need to attend to some legal planning so that when you are gone, things are straightforward for every loved one you leave behind. The importance of a will and power of attorney. If you own any type of asset, real estate, a business, valuable, jewelry, cash accounts, RVs, and others, vehicles and other things, etc., you need a will. A lawyer needs to draft it for you. This is not a do-it-yourself document. A will is a legally binding document that tells the authorities, the executor of your estate, and all of your loved ones and beneficiaries how to dispose of your property upon your death. When you are a parent with minor children, you draft a will. Its intent is usually about the care of your children in the event of your death, while they are still underage. A will is also important, whatever your age might be, if you have disabled adult children still in your care. Real people, structuring to save on probate. A GIA, or guaranteed interest account, is similar to a GIC at your bank, but is issued by an insurance carrier. Money in a GIA sits outside probate and has creditor protection since it is not visible to anyone looking into your probate settlement. A client named Roberta had $200,000 in the bank. We transferred her money into a high-interest savings account with an insurance policy and a GIA. It is all kept outside of probate. It is, however, still accessible if Roberta ever needs it. Real people, common law partner versus marriage. In my province, common law partners have very few rights. Rita had been with her common law partner Mark for 8 years when he died. Mark died intestate, which means he had no will. Because of that, his assets went to his children. Rita was left in the cold, literally, since Mark's daughter immediately kicked her out of the house they had been living in. The daughter gave Rita the statutory 30 days to vacate the home. Not only was Rita mourning her late partner, but she also had no home, no rights to any of his assets, and no recourse. If Mark had drawn up a will, he could have left her everything, and it would have been his daughter and other children who had no recourse to change things. The power of attorney. A power of attorney, or POA, is a binding legal document. This legal document authorizes an individual or corporate trustee, such as a legal firm or bank, to make decisions on your behalf. The types of decisions the designated individual can make are specified in this document. You may have heard the term executor. The main difference between an executor and a POA is that the POA may act during your lifetime on your behalf, while an executor steps in upon your death to fulfill the terms of your will. A POA is of two types in Canada. 1. Personal care. In case of your incapacity due to an accident or long-term illness, the POA grants the ability to the named individual to make medical decisions concerning you. If you do not have a POA and a family member is not present to make such decisions, the hospital will make medical decisions in your best interests. 2. Property care. Property here means all your assets. The individual is authorized to make your payments or banking in your place. This POA can be active even when you are not incapacitated. In other words, you do not have to be ill or otherwise incapacitated at all. If you are a business owner, you should have a separate will for this asset. Often your incorporation or your partnership agreement places your business outside of your will. If not, consider drafting 2 separate wills. Choosing your POA. The person or institution you name as your POA has a lot of power, so be sure you trust them. Choose wisely. Remember, a POA is in effect during your lifetime. You don't want this person or institution's personnel to walk off with all your assets or mismanage them so you are left destitute. One key to choosing the right person is making he or she is up to the task. You need to know that this person can take care of your affairs. Upon your death, your executor would become responsible for filing all your tax returns in Canada and other countries where you are liable for taxes for the current and all past tax years you may not have filed. The executor will be closing out all of your investment accounts. An executor may potentially be involved with your disgruntled family, so this person might need to be thick-skinned and not take complaints personally. Life is full of changes. Update your will, your life insurance policy, and your POA designations. Take a new look at your beneficiaries. Every time you have a life event happen, a divorce, a remarriage, the birth of a child, the death of a beneficiary, or an investment in or divestment of your assets, you need to do this, especially once you get older. Do this check-in once or twice a year, just like changing your home smoke alarm batteries. The future value of your estate. In leaving legacies, I encourage my clients to consider the future value of their estate. Project the values of your assets as you prepare for retirement and during your retirement. Many people retire and live for another 30 years. History shows us that real estate values, the value of gold or silver, and the valuation of businesses all rise and fall. How might your assets values rise or fall before your death? How might they be leveraged to support your income in the future? I am often asked, what about putting my kids' names on a house or bank account? This is different from naming them as a POA. I get asked about this all the time when individuals get older. The answer is not easy, but there are some things to consider. First, are your children trustworthy? Do they have the capacity to manage those assets for you if needed, rather than mismanage them? Next are the tax implications. If 30 years ago you invested $200,000 in a lakefront cottage and it's worth $1.2 million today, you will have to discuss the tax implications of selling it. If it is not your primary residence, the tax will be owed. If you still own it upon your death, your beneficiaries will owe tax on the capital gain when they sell it. But how much? Unless you organize your finances properly and have a discussion with a financial planner like me, you may not know until it is too late to adjust. I do this kind of calculation and tax estimation for clients all the time. Such a discussion also helps you make sure that what your financial position is if you sell a primary residence and downsize to something cheaper at the time of retirement. What is the tax implication on profits you've made, and how much is left to plump up your retirement funds? Ask me. This asset and tax discussion also clarifies your legacy to beneficiaries. If you had planned to leave property to one or more children, how can you structure it so they do not lose the benefit of the inheritance through a huge tax bill? Your family will thank you for structuring your assets properly. My strong advice: take care of your assets year after year and not just a once and done basis. Take care of how you structure your legacy through the will and the POA, and make sure your advisor is giving you complete information about your assets, cash flow, tax picture, legacy, and all your options. If your advisor doesn't keep in touch with you, change advisors. They are paid to do this type of analysis, follow-ups, and corrections. However, you need to be in touch too with them to get this done. Real people, a deed gone wrong. 20 years ago, Jasper and Rainey put their 2 kids on the deed of their primary residence with them. They had imagined leaving the property to their 2 children in equal shares upon their death and wanted to avoid probate and the associated $15 per thousand fee. Fast forward, and Jasper and Rainey are both in a long-term care facility. They sold the house while they were alive. They bought it at $200,000 and sold it for $800,000. The couple had no capital gains tax on their respective 25% gain because it was their primary residence. Both children, however, owned other property as their primary residences. When this sale went through, each child therefore owed tax on their respective $150,000 capital gain. It turned out not to be such a great windfall for the kids. The 25% gain needed to be declared as taxable income by each child, probably adding an extra $25,000 each on their tax bills that year. Thankfully, the children did not have any marital or financial issues during the time their names were on the home. Had one of the children gotten divorced or been sued, then that would have also added another layer of complexity. Putting your child's name on your bank accounts is a bit different, but can be just as risky, or more so. The ease of paying bills draws elder people to this solution, so they add their child's name to the account and hand the checkbook over to them. However, the temptation to drain their mom's or dad's bank account is real. My folks would have wanted me to have some or all of the cash to do blank. There are many court cases dealing with this type of scenario. Like naming an executor or POA, you have to trust the named individual. The tax picture requires the POA to get expert advice. There is a probate process to understand. Does your POA understand all the fiscal and legal obligations? Also, keep in mind that family members are not always close at hand. We are a mobile people. If your preferred executor lives outside the country or across the continent, you might consider another individual for the job. Deemed disposition and final taxes. Structure things properly. If the husband dies, money in the RRSP or RIF rolls over tax-free to the surviving spouse. When the surviving spouse passes away, the tax authorities apply the principle of deemed disposition. This is the fair market value of the account on the day the wife died. The money value is what the authorities calculate the tax on. Is there money available for that tax bill? Just a note, spousal rollovers are not always the best option. If your sale of an asset or a business or piece of property is going to generate a capital gain, and if so, what are the type of tax implications it has? What are the ways to mitigate that tax picture?